Hey, folks, if you haven't done so already, please click that subscribe button below. That'll help us grow as a show, attract better guests. Together, let's make healthcare better for everyone. Once again, click that subscribe button. We'll see you on the next one.
Get ready to take control of your healthcare. Here's your host, Ray Cobra.
And we're live, ladies and gentlemen. Welcome to Broken Healthcare. My name is Ray Cobra. I'm your host, and I'm delighted to have with us today our next guest, Dr. Dae Lee, a true triple threat in the world of healthcare and life sciences. He's a PharmD, an attorney, and a certified pharmacy benefits specialist. As a shareholder in the FDA and biotechnology practice at Buchanan, Ingersoll, and Rooney, Dae brings a rare combination of clinical, legal, and policy expertise to the table. He advises pharmaceutical companies, independent pharmacies, healthcare startups, and Fortune 500 firms on how to navigate some of the most complex regulatory and commercial challenges in the industry, from FDA compliance to drug pricing, PBM strategy, and beyond. He's going to teach us a lot today. Welcome to the Big Show, Dae. How are you?
Good, thank you.
Oh, wonderful having you here. So I guess I ran into you at one of the conferences. I think it was the National Alliance of Healthcare, National Coalition of Healthcare Purchasers down in D.C., and you were on a panel with another attorney that I had the pleasure of interviewing here as well. I think it was Julie Selesnik.
Yes.
And you guys had a very lively discussion about what's going on in healthcare and the healthcare space, and particularly on the pharmacy side. We were just talking before we fired up this interview, and you have a little bit of schooling in your background. I think you said 9 years. It's a lot of school. Let's jump right into it. What do you think about the current state of healthcare and the opportunity for business leaders who are looking to manage this top payroll expense, typically, or top SG&A expense, typically number one or two after payroll, healthcare? What is their opportunity for savings and to do better than kind of the status quo?
Right now, a lot of positive movements for pharmacies, plan sponsors, and employers to make the entire system transparent. So when the system becomes transparent, then the drug spend goes down, and then patients' out-of-pocket expense goes down as well. So there's a lot of moving pieces right now.
Yeah.
And as you know, PBMs, pharmacy benefit managers, they're supposed to administer and manage prescription drug benefits of employers and plan sponsors. And they have done that, or they had done that at the beginning of their creation. However, throughout the past decade or so, they have become, they realize that, this could be really lucrative for them at the expense of the plan sponsors and at the expense of the patients. And so they started creating this vertical integration model where they own everything under their umbrella. As you may know, right now there are only truly 3 large PBMs that control 80% of the prescriptions in the United States. These are CVS Caremark, OptumRx, and Express Scripts. And they are part of this large, umbrella of vertical integration model where their parent companies and their subsidiaries own almost everything from top to bottom. CVS Caremark is owned by CVS Corporation, who owns insurance companies like Aetna, SilverScript.
Right.
And then, there's PBM, which is Caremark. And then from there, you would have rebate aggregator called Zinc. And as you know, CVS also owns retail pharmacy. They also own mail order specialty pharmacy. Same thing for Optum. Optum is part of the United Healthcare system, and they have United Healthcare plans. And then PBM has OptumRx. Then they have their own rebate aggregator called Emistar Pharma Services. And Emistar is located out of Ireland. And then Optum also owns their own mail order pharmacies. Same thing for Express Scripts. Express Scripts is part of Cigna, and all Cigna plans, and then underneath it, Express Scripts, and Express Script owns its own rebate aggregator called Ascent Health, located in Switzerland. And then they have their specialty pharmacy called Credo. And, in that vertical integration, they've expanded into group purchasing organization model. They are expanding into physician groups. So they now own everything under one umbrella, from insurance company or insurers down to provider level, which creates this whole system more opaque because there's more layers under one umbrella.
Yeah, it's crazy to me because we hear about, the DOJ going after companies for monopolistic practices all the time in the tech space. I don't think you really think about it in the healthcare space, but what you just described sounds very much like a monopoly to me, right?
Correct.
You have all of this, activity. These are business units underneath the same umbrella of an insurance entity, and it's. I still laugh. It puts a smile on my face when I think that CVS bought Aetna, right? Because it's counterintuitive. I think most people, including myself, would think, oh, the insurance carrier, they're the big giant gorilla, but it's not so. They were acquired by a pharmaceutical company, right? And so all of this, these gyrations that they're going through, is the kind of moving part of the business overseas to Ireland and Switzerland. Is that something that's new, or has this been kind of the practice for many, many years?
No, it's fairly recent. Optum used to have a United States-based rebate aggregator called Coalition for Advanced Pharma Services. I think they wrapped that entity in around like 2017 or 2018 possibly. And then they created Emissar. And then Express Script is very recent that they created this Ascent Health in Switzerland. So it's fairly recent development. And one thing about vertical integration is that, these PBMs are perfecting the vertical integration, almost like, I want to say 95%. And they've done that, and the whole, the system allowed them to do so. At the same time, because they are perfecting the vertical integration, now they're creating horizontal partnerships with other PBMs. So a lot of smaller PBMs are now depending upon these big three PBMs and their rebate aggregators in order to survive. So it's very difficult for a prescription claim not to be touched by these top three PBMs or their subsidiaries.
So they really are controlling the marketplace, is what I'm hearing. If you have small PBMs that can't compete, because essentially, I don't want to use the wrong terminology, especially with you being an attorney, but it sounds like price fixing to me. And ultimately, they're the conduit to the very survival of these smaller competitors. That seems ass backwards to me. It just seems like, hey, there's something smells rotten in Denmark.
Right.
Yeah,
Exactly. I mean, these smaller PBMs, they try to compete. They try to compete with these top three PBMs on a more transparent model.
Yeah.
And the plan sponsors and employers are getting educated. But at the end of the day, these the smaller PBMs, it's very difficult for them to compete.
Yeah.
And in terms of rebates, smaller PBMs cannot go to a brand name manufacturer and get the best rebate deal out of the manufacturer. So they depend on the rebate aggregators owned by the big three PBMs, or they just deal with the big three PBMs in terms of the rebates.
Sure. Well, they're dealing with these giant entities, right? And I don't have expertise within pharma in terms of supply chain, but early in my career back in the day, I worked at B&H Photo Video, which was maybe 200 employees. They're now 2,000 employees. But even back then, they were able to essentially sell product at a price that the competition just could not match because they had access to funds. They were extremely savvy buyers, And, Sony Electronics, for example, I had one of the executives tell me, they are very particular about who they do business with. They examine the financials thoroughly. When it came to B&H, they were like, back up the truck. So they had tremendous buying clout. And you're talking about a relatively small business. Maybe they're several $billion in revenue now. Imagine a Walmart or an Amazon, right? And so this is kind of the scale that we're talking about with these giant insurance carriers. How could the little guy, possibly keep up? But what strikes me for our listeners and our viewers on YouTube is that how does this affect them and their pocketbook? Well, it directly affects them, because if you have these big giant gorillas that are manipulating the price action, essentially assuring that everything possible flows through them, they're taking a piece out of the pie. And it's crazy, because this rebate game, we talk a lot about transparency on this show. And at the end of the day, if I look at a healthcare system, and in a market like New York City Metro, where we are, we know who the giant players are, right? The New York Presbyterian, Columbia, Mount Sinai, NYU. These are the giant hospital systems, and there are others. But their charge master might have 200 different rates for the same exact CPT code. And how can we expect, the general public, our fellow Americans, to understand what a good price is when they can't even give us the price, right? It's so convoluted. And what I'm hearing from you, though, is this is very much kind of endemic. This is part of the issue that's baked into our pharmacy benefit supply chain. And so what is your role, and how do you address this? Because you're a litigator as well, right? You basically take these guys to court.
Yes.
And so how does that go?
So
how does little old you compete against the big guys?
Yeah, I mean, I sue PBMs for a living. I represent pharmacies, I represent plan sponsor employers.
Yeah.
My end goal is to make sure my clients' interests are leveled, right, and protected. As for plan sponsors, I've been educating them because of the PBMs and the vertical integrated model that they created. Is very difficult for plan sponsors to look under the hood. Plan sponsors did not have access into the claims data. They did not know how much the PBMs are, siphoning monies away from them. But now there are certain laws, right? Like, for example, a CAA, Consolidated Appropriations Act, and that mandated plan sponsors to, or allow plan sponsors to, gather claims data and also have PBMs or other service providers to disclose direct and indirect compensation that the service providers are, raking in. So, I'm going to give you an example of how PBM perfected a vertical integration model, and that actually impacted the plan sponsor, but also the patient's out-of-pocket expense. So there are a laundry list of cases, publicly available cases. For example, Ohio, right? In 2017 or 2018, Ohio Auditor General, now is the Attorney General, Dave Yost, he audited Caremark, and then he audited OptumRx, and then found out that both PBMs created spread pricing tactic and then siphoned away about $215 million from the state's Medicaid program. So spread pricing is literally creating a spread between what PBM actually charges the state or the plan sponsor, and then what they actually pay to the pharmacies. And of course, this data is insulated from the plan sponsor unless the plan sponsor knows what they're doing when auditing the PBM. And Ohio Auditor General Dave Yost knew what he was doing, so he uncovered this, meaning if Caremark, Optum, Express Script, or any other PBM charges employer $1,000 for a prescription drug claim, and then the PBM actually only pays a pharmacy, independent pharmacy, $100, that's $900 delta. That delta is in their pocket, and delta is called spread. and there's about $250 million of spread between those two, Caremark and OptumRx, when they actually bill the Ohio State for the Medicaid. I mean, it's state Medicaid program. And imagine what they do with this private commercial insurance plans.
Wow. Yeah, because that's our tax dollars at work, right? Medicaid, Medicare, it's all funded. TRICARE, it's all funded by our taxpayer dollars. And so you're not talking about a small amount of money. $250 million
Exactly.
is a lot of money. And that's just, in the pharma vertical. And so it's just mind-boggling to me that this is kind of happening right underneath everyone's noses, right? It's not apparent to us. We're great at shopping on Amazon or online for a pair of jeans or a barbecue grill or tennis balls or pick a flavor, right? It's very easy to see what competition looks like and to figure out, based on reviews, what the best product is. No one's paying attention when it comes to their health insurance and particularly to their drug pricing. I think people are starting to catch on a little bit, but it's definitely the minority. It's not the majority. And when you have an attorney general that takes notice, I mean, kudos to him for, identifying that there is an opportunity here to uncover, let's call it not a best business practice.
Mm-hmm.
And simultaneously, what was the outcome of that? Were the insurance carriers / pharma giants, did they have to atone and pay?
I believe not, because I think when Dave Yost became Attorney General, he started suing PBMs for the spread pricing and all the rebate of fees taken away by the rebate aggregator. So there are multiple lawsuits pending in the state of Ohio.
Okay.
Yeah.
So they're still in the courts. They have not been settled yet.
Not to my knowledge. Maybe one or two cases may have settled.
Right.
And in terms of a settled cases, I could give you another example.
Yeah.
Involving rebate. There's a county called Broward County in Florida.
Okay.
Broward County audited the then PBM OptumRx. I think the claims were 2017 or 2018 claims, 1 year audit. And the county found out that OptumRx, unbeknownst to the county, without seeking approval from the county, delegated the rebate function, aggregation function, to its then rebate aggregator called Coalition for Advanced Pharma Services, in short, CAPS. CAPS then subcontracted out some of the rebate aggregation function to Express Scripts. So CAPS negotiated and collect the rebates from manufacturers, pharmaceutical manufacturers, and Express Script, negotiated and retained rebates from the manufacturer as well. Then those rebates were not passed on to the county, and it was kept in the, rebate aggregator and Express Scripts pocket.
In the PBM, yeah.
Yeah, and OptumRx. And, and then the county, in the contract, I believe it says that, the administrator, which is a PBM, will pay 100% of the rebates it received, it meaning Optum, not this rebate aggregator, not Express Script, to the county. And county didn't like that, and they entered into a settlement agreement, and I believe Optum paid back about $800,000 back to the county, and it's a lot of money for the county.
Right.
So these type of things, like PBMs abusive and self-serving tactics are happening at the government level. So is no doubt that they're doing more egregious things in the involving, private plans or commercial plans.
Right. Well, and that's just it. So the breakdown is that private insurance represents 55% of the healthcare coverage out there. It's bigger than Medicare, Medicaid, and TRICARE combined.
Right.
And so if the waste, fraud, and abuse is happening at the government level, to your point, what's going on at the private level.
Right.
And the hard thing is, I think, the general public, and I'm going to include chief executive officer, CFO, head of HR, everybody that's involved in procuring healthcare on the supply chain side. They're no different than you and I or any of the people that they employ, in that the perception of medicine is it gets put on a pedestal. It's your doctor is kind of sacrosanct. And when you think about your insurance and the logo on your ID card, it's something that folks are very reluctant to play with. They are motivated by the four-letter word that starts with F, that is fear.
Mm-hmm.
Fear. And they're afraid of change. Should they be?
Yes, they should be. I mean, they shouldn't be afraid of change, but they should be afraid of lawsuits. Right now, I want to say there are 3 lawsuits filed by employees, class action lawsuits against employers for allegedly failing to properly manage the employees' prescription drug benefits. And so first case was, I want to say, Johnson & Johnson.
And Dae, so what you're referring to is the passage of the CAA, the Consolidated Appropriations Act of 2021. And essentially, it puts healthcare on the same level. It's on par with an employer's fiduciary responsibility to manage a 401k, pension plans, et cetera, et cetera. Essentially, the CAA holds employers now to the same standard with respect to their health plan. And what you're saying is that we're now starting to see litigation, action, lawsuits coming brought by employees that are saying, you didn't fulfill your fiduciary obligation. You didn't spend plan dollars wisely, particularly when employees are funding these plans. In some cases, more than 50% of the premiums are funded by employees. So that's a high standard. And what you're saying is employers better take heed because they could be next.
Yes, not only employers, but also the HR benefits or the executive committees. They are all, and the individuals who's making those executive decisions, they're now exposed to lawsuits. And in fact, those 3 lawsuits that I mentioned actually named those committee and the individuals.
Huh. So wait a second. Time out. So I'm now the CFO. And I work closely with HR. Let's say the CEO is removed from it. I'm sure that doesn't, preclude them from being named in a lawsuit and being personally liable as well. But what I'm hearing you say is that their S's are on the line, and they can be personally sued. And so, if I'm right in saying that, where does the corporate veil come in and insulating shareholders from these types of lawsuits, or does that not come into play?
Well, these are the folks, and the committees are the ones that are making those decisions about beneficiaries' prescription drug benefit design. So they are held to the fiduciary standard, and they are now exposed to those lawsuits, like Johnson & Johnson lawsuit, Wells Fargo lawsuit, and JP Morgan Chase lawsuit, all filed by the employees. They all named the executive committee, the compensation committee, and then the individuals making those decisions. And also, I'm glad that you mentioned 401k and retirement funding issues or cases. These are the plaintiff firms that have already proved their theory, breach of fiduciary duty theory in those cases, are now in the prescription drug benefits cases or arena. And then these 3 lawsuits, all filed by the same firm. And they are recruiting other employee plaintiffs against other employers. So I highly recommend employers taking a closer look at their PBM agreement, the pricing, and their relationship, and also their relationship with the brokers. And, sometimes, if not many times, brokers are incentivized. They receive incentivized compensation from the PBM that they recommend to the plan sponsor.
Sure.
So I think there is a conflict of interest.
Yeah.
And nobody's monitoring the PBMs. I mean, if your broker says, "Oh, I do annual audit of the PBM," to me, that's a beauty contest. It's not a real audit. You have to. An employer must monitor and audit the PBM, the contracted PBMs, to make sure that PBMs are not only abiding by the contract terms,
Yeah.
but also making sure that they're managing the prescription prescription benefits properly. Otherwise, employers fail to perform their fiduciary duty.
Yeah. So the Healthcare Podcast is brought to you by Benefixa Healthcare Consultants. Visit benefixa.com to learn what's possible. Reduce the cost of healthcare for your organization, deliver better outcomes for your people, and yes, design health plans that give your people a path to $0 out-of-pocket costs for healthcare. Visit benefixa.com. Yeah, so there's a lot to unpack there. You said a mouthful. So I'm gonna rewind and start with the conflict of interest, right? So we have big box brokers, let's call them, with buildings and skyscrapers in Manhattan. These are multi-billion-dollar entities, and they are essentially in bed with the insurance carriers. They're partners, right? When your premiums go up, so does their compensation. Let's just call it that. It's as simple as that. So part of, I think, if we look at the golden age of the brokers, and I think we're most definitely still solidly in it, is they lavish their clients with trips and, courtside tickets and tickets to the Masters tournament. And, these may cost some of these entities tens of thousands of dollars. And, those folks, those executives that are listening are probably snickering right now saying, no, Ray, it costs us hundreds of thousands, if not millions of dollars. That money is coming from somewhere, though. And so ultimately, as a business leader, I think you have to look at it and say, well, it was nice while it lasted, but this party is over now. And I have a responsibility to look out for the benefit of our firm, of our business, of our organization, first and foremost. And what I would say to those folks is you can, if you dive in and you manage the supply chain of healthcare, and particularly on the pharma side of the house, I think there's, on average, I'm going to say if I lowball the estimate for the opportunity for savings in a traditional plan, somewhere in the ballpark of 30 to 60%. And if you're spending millions and millions and tens of millions and hundreds of millions for large enterprise organizations on healthcare, that is an enormous amount of money. And I think now we're starting to see the kind of bubbles rising to the surface where entities are starting to be sued by employees. And so I guess the other thing that I wanted to touch on is, where are the lawsuits coming from? How, of some of the suits that you mentioned, how are the employees savvy enough to know that there's even an opportunity there? Because are they being guided by an attorney? Are they, can you give us any of the details on any of these cases, like the progression for, what the claim was that the employee made and, what the allegations were? What does a class action suit look like?
I think right now employees and beneficiaries are getting educated, and frankly, I think they're fed up with, annual increase in premium, annual increase in their out-of-pocket expense. And if you look at Johnson & Johnson case, the plaintiff alleged that among others, plaintiff alleged that Johnson & Johnson paid for one drug claim for $14,000. And that drug claim or that drug alternative therapy is also available in the market for cash price for, I want to say, $25 or $50. Oh so there's a huge markup.
Yeah.
And the other thing is, because of the vertical integration, it allows PBMs to dictate where the drug is going to get actually filled at. So all these cheap generics, it can be filled at independent pharmacies. But the specialty generics, those real expensive ones, and also brand, sometimes and many times it can only be filled at the PBM's own pharmacies.
Right.
So the drug claim is, it lives in the PBM's own ecosystem, and then it contributes to ever increasing drug spend, out of pocket expense, and also the drug price, because PBMs demand higher rebates on brand drugs, and manufacturers they don't have no option but to, abide by PBM's request, because you spent millions of dollars into developing this drug. You have so many years until the patent expires. You got to make sure that drug is in the PBM's formulary, and in order to be in the PBM's formulary, is pay to play. You got to pay up in order to have your drug in the a better tier formulary, so that it can be covered by beneficiaries' insurance coverage, and then it can be filled at whichever pharmacy that the PBM dictates.
Right. So, what type of an argument does defense have? So you do a face-off in court, and I guess what I'm really asking is, in your opinion, does most of this stuff get settled at a court because their practices are indefensible, or do we see these court cases playing out to a verdict, and then what do the punitive damages look like?
I mean, right now it's too early to tell. Johnson & Johnson's case got dismissed without prejudice because of lack of standing, and then the plaintiff filed second amended complaint. So it's still being litigated. Wells Fargo case got dismissed for the same reason, and I'm sure Wells Fargo plaintiff will amend the complaint and file it again. And then J.P. Morgan case is the third one, and it has I don't think it has been dismissed, and it has more I want to say meat to it, more specific allegations, and plaintiffs and plaintiff firms, they're gonna learn, and then they're gonna perfect their theory, they're gonna perfect their approach, and employers are at risk.
Yeah.
And in order for employers to fulfill their fiduciary duty and truly contain the drug spend, and then the premium and out-of-pocket cost, they have to monitor the PBMs, and then they can't just trust their broker, blindly, and who recommends one PBM. And they have to really check the broker's incentives and make sure that the brokers do not have conflicts.
Right.
And if they do have conflicts, they better disclose.
Yeah. Well, it blows my mind because the conference that we met at, National Alliance of Healthcare Purchasers Coalition, it just blows my mind how many large employers are there, because they're aware of the CAA. They're aware that they need to do a better job of sourcing health insurance and health care for their people. And it just blows me away that so many of them are still aligned with one of the big three. And how it just seems to me that the day of reckoning is pretty much here. It's just a matter of time before these large entities start getting hit with these lawsuits. And I think if I'm sitting on the executive team, my conversation is going to be, well, how do we A, do a better job of procuring drugs on behalf of our members, and B, how do we insulate ourselves from being one of those companies that, a lawsuit is filed against? And I'm sure that must be part of your discussion with employers every day. And what is your advice to them?
Yeah, I mean, my advice is it has been and will continue to be, audit your PBM. Make sure that, whenever you conduct a RFP process, don't rely upon the broker. Be in the driver's seat, drive the contract process as well. Don't just delegate it to or hand it off to the broker or the PBM.
Right.
Because if you do that, you're literally handing over a blank check
Right.
to the PBM, and then they could do whatever they want.
Right.
And all these, like, I've reviewed hundreds of PBM agreements for employers.
Yeah.
Many of them, if not most, especially the older ones, it's cookie cutter contract terms, you know, and it allows spread pricing. It allows the PBM to contract with any of the rebate aggregators that they own or affiliated with and take money off. And I've audited PBM contracts and the PBMs themselves many times. And, you know, always I find spread pricing. Always, I also find the spread pricing in the rebates. You know, one thing that is also contributing to the increase in drug spend and drug price is the rebates. And rebate aggregators and PBMs, they take percentage off of the rebate as their fees. And it could be, you know, whatever jargons that PBMs can come up with. You know, price protection fee, inflation protection fee, or gateway fee, whatever it is.
Yeah.
And plan sponsors don't know about that. Plan sponsors many times don't even know a rebate aggregator was involved because they allow the PBM to dictate the contract.
Right.
And because of the vertical integration model, PBMs can do whatever they want. They could use their own rebate aggregators.
Right.
And the more fees taken away by rebate aggregators and PBMs, the lower the rebates that's going to be ultimately passed on to the plan sponsor. And rebates are supposed to be used to reduce a plan sponsor drug spend.
Exactly. So the rebates are coming by and large from the manufacturers as a way to offset the cost of the drug, but the intent is for that rebate to make its way back to the plan sponsor, the employer, and the member.
Right.
And often it's being eaten up by the PBM, which is owned by the insurance company that's sitting in the middle. It's just crazy.
Right.
And so, you know, I think about this. So I don't know if there's such a thing as an average, but what would you say is the typical, how many pages is a typical PBM contract?
There's no like average, but you know, anywhere it could be between 10 to 40.
10 to 40 pages.
Yeah. And then, I mean, I've reviewed PBM agreement for Fortune 10 companies.
Yeah.
Or global companies.
Yeah.
You know, it's one and the same. And then these are, you know, companies that have used a PBM for over a decade, never audited.
Right.
Just amendment after amendment. So much dirt, so much loopholes that allowed the PBM to rake in money.
Right.
At the expense of the plan sponsor, at the expense of the beneficiaries.
That is just crazy to me. You know, and, you know, folks, if you're listening and you're the CEO, you're the CFO of one of these companies, I mean, I could only imagine like a Fortune 10 company has got a multi-billion-dollar a year budget for healthcare. And if we're talking about 20 to 30% being super conservative of that budget being pharmacy fees, right? Drugs. And then you have the ability to optimize that and cut your costs anywhere from 30 to 60%. You're talking about a huge amount of money that can just flow directly to your bottom line and have those dollars repurposed to benefit your organization and your people. Why wouldn't you do that? That even goes beyond their fiduciary obligation under the CAA. It's just good business as far as I'm concerned. But it boggles my mind that so many are complicit, you know, when it comes to this expense. And, you know, to your point, like a Fortune 10 company that never did an audit until you come along. That I think that's the epitome of negligence. You're negligent if you're not participating in, you know, breaking down this expense and kind of inspecting what you expect. Oh, nuts. So, with these recent cases that are brought, and you're saying that some of them were dismissed and they're being refiled, and there's another with J.P. Morgan Chase that's still out there. And that case, I think, is particularly interesting because Chase holds their own healthcare summit every year out on the West Coast and talks about ways that businesses and organizations can be better consumers of healthcare, how they can optimize the supply chain. And so that is a case that I'm going to follow because I'm very curious as to what their defense will be when they kind of didn't drink their own tea.
Right.
Right? It's just what do you think? What do you think they're going to say?
I mean, they may likely say that, it did not contribute directly to the employee's increase in premium, but I think the plaintiff can prove, that because of their mismanagement, their premium, the plaintiff's premium went up, and then the plaintiff's out-of-pocket cost went up drastically. So, and then it's the same plaintiff's firm among the three cases.
Yeah.
And I'm glad that you mentioned about why employers are not doing enough. I mean, I think number one is because PBMs have done a great job hiding stuff, right? Hiding their tactics, coming up with these schemes. But now employers are more being educated. However, still, it's sometimes relationships, right? Relationships control the arrangement. I'm going to give you an example of Centene. Centene is a nation's largest Medicaid managed care organization. I think Centene is the MCO for 36 states, last time I checked. Centene reserved about $1.1 billion to settle with the state Medicaid programs. For the same reason, overbilling the state Medicaid program through different tactics. Some of the states already settled, like I believe California settled hundreds of $millions, and some other states also settled in that range. But some of those states actually decide to keep Centene as their MCO. So Centene robbed you, and then you still you continued the contract with Centene.
Right.
So you're okay with getting robbed, and you're giving them a second chance.
Yeah, that sounds very dangerous from a risk perspective.
Right.
If I don't see how anyone rationally makes that decision to keep on keeping on when the fraud has been uncovered. That's just
exactly
that's crazy.
And then I think the only logical reason behind that, if any, is the relationship that Centene may have with higher ups in those states.
Right. Interesting. So getting back to and power corrupts and absolute power corrupts absolutely. And we're dealing with this. This is not this is not a low stakes game. This is high stakes. And, I learned from a friend of mine in the industry, he's a brilliant guy. His name is Craig Lack. The smartest guy in the room is always going to be the attorney representing the big PBM. They are excellent at just bending or stacking the cards in their favor. They're expert at it, and I think that makes it an uphill battle and very difficult for employers to gain an advantage. And so, but it doesn't indemnify or protect them. In fact, now with the passage of the CAA, they really need to pay attention. And I guess my question to you, though, is we mentioned, going through this PBM contract, 10 to 40 odd pages, whatever it may be. Are PBMs amenable and open to changes if you redline a contract like that, or do they generally say this is the contract, take it or leave it?
plan sponsors.
Yeah.
I want to say when I represent plan sponsor, their demeanor is very different than when I represent independent pharmacies.
Okay.
They want to push against independent pharmacies, to the end. For plan sponsor, it's a little bit different. So, for plan sponsor, I think the PBMs are more acceptable to the red lines and changes proposed by plan sponsors. For independent pharmacies, no. It's take it or leave it. And there are certain states that mandate PBMs to negotiate with the independent pharmacies. But I have several cases that I've done that for independent pharmacies, but that's not, that's only like few and far between.
Yeah. Help me understand the market. How many independent pharmacies are out there across the U.S.?
I want to say anywhere between 18,000 to 22,000.
Okay.
The numbers are getting smaller, obviously, because of PBMs, low reimbursement rates and their, constant audit efforts, and termination.
Yeah.
But market is very right now. The market is very, I want to say, diverse and volatile because certain state laws, like for example, Arkansas passed a law saying that PBM in our state, in the state of Arkansas, PBM cannot own a pharmacy, and that's going to go into effect January 1st of next year. And then immediately after, CVS announced that it's closing its stores in that state.
Wow.
So that's probably around like 20 to 22 stores.
Right.
So, and where are the prescriptions going to go? It's going to go to the independent pharmacy in that state. So it's going to definitely boost the pharmacy's prescription volume.
Right.
And some of the chain pharmacies are closing down, including CVS throughout the nation, and Walgreens as well. So in certain areas of the country, independent pharmacies are, opening up. And also the existing ones are inheriting a lot of prescriptions. But that does not mean that pharmacy is going to make money or profit on every single script. Pharmacy is going to lose money on a lot of scripts because of the low reimbursement rate and the acquisition cost. Like, for example, Ozempic, right? If an independent pharmacy submits a claim for Ozempic, that pharmacy will probably lose anywhere between $100 to $200. So that pharmacy will likely transfer that prescription to somewhere else. So PBMs have become they're the middlemen, right? We call them middlemen, and they're right in the middle of it, controlling the flow of the prescription. So it has a lot of control over independent pharmacies, because independent pharmacies, if you want to submit a insurance claim, you're going to have to submit it to Caremark, OptumRx, and Express Script, because those three own 80% of the market. Without them, it's very hard for independent pharmacy to survive. However, there are, I want to keep a positive tone, because there are state laws that allow independent pharmacies to protect their interests and grow their business.
Okay. What does that mean, though? Protect their interest and grow their business. But how do they do that if they're not doing business with the big three?
So, no, you have to do business with big three, but in the process, you could do the reimbursement dispute. And if they try to terminate you, there are certain laws and also standards in the PBM provider manual that protects against the unwarranted termination. And also there are state laws like pharmacy fair audit laws that gives legal tools for the pharmacy to fight against unwarranted PBM audit findings. And these audit findings can range from anywhere from a couple $1,000 to 10 or 15 million. And do you think that PBM recoup all the money and going to pass on to the plan sponsor? No, that's not happening.
That fantasy is not going to come true.
It's another spread tactic.
Wow. So if I think in our space about fiduciary PBMs, so these are independent pharmacy benefit managers that actually name their client as their fiduciary obligation is their client, right? And they actually put that in writing in their contract. I don't know if you know the answer to this, but are they beholden to the big three? Are they doing business with the big three? Do they have to as part of the process, or are they sourcing every drug that they procure through alternative channels?
Most of them, they try to do it on their own, but sometimes they have to get the rebates through the rebate aggregator owned by the PBMs, or sometimes they have to lease the pharmacy network of a PBM, major PBM, in order to provide the network of pharmacies to the plan sponsors, beneficiaries. So they're not entirely independent. I don't think anybody is entirely independent of the big three PBM, but their model is certainly more transparent than the big three.
Got it. Yeah. And there are some good ones out there for sure. And I've experienced firsthand, the numbers don't lie. They are delivering for their clients to the tune, generally, if I had to use a broad brush, I would say the savings typically are in the ballpark of 50%, which is tremendous.
Yes.
When you consider that it's 30% or more of your overall claim bucket. So your day to day in terms of what you do and who you interact with, and how do you find clients? Is it inbound? Is it outbound? Is your firm holding seminars? I guess that's interesting to me, just how client acquisition happens. And then if you looked at a breakdown of your clients, what represents the biggest kind of bucket for clients that you serve?
I mainly serve independent pharmacies and plan sponsors, and I do a lot of marketing, whether it be speaking engagement like this, or articles or webinars, and I get a lot of referrals from other sources, pharmacy associations, sometimes board of pharmacy, or word of mouth. So
And so an independent pharmacy who is aware of what you do, give me an example of them engaging your services. What happens that prompts them to pick up the phone and say, Dae, I need your help?
PBM audit, PBM termination. Those are the main ones that they call me for. Or sometimes PBMs share the audit findings with governmental bodies, such as OIG, Office of Inspector General, or the Medicaid or Medicare fraud task unit, which also prompts separate investigation, or board of pharmacy. So all the work that I do involve PBM at a certain level. And independent pharmacy is more like I said, PBM audit, termination, suspension, board of pharmacy work, and other governmental investigation. And for plan sponsors, it's more of me reaching out to educate them of the potential, lawsuit risk by their employees, and ways to make their PBM agreement more transparent that will ultimately reduce the drug spend and premium and the beneficiaries' out-of-pocket expense.
Interesting. So I guess a best practice for an employer would be to have a regular process for reviewing their agreements and auditing claims and documenting it, right? So that if the DOJ comes knocking, they can turn around and say, we are aware of our fiduciary obligation. Here's our process. This is what we've done. This is what we continue to do. I would imagine that if an employer has, access or can present the DOJ with files that detail their process and check all their boxes and can turn that around quickly, that I would think would be a best practice that any employer should, if they're not on it already, they should get on it.
Yes, and it also reduces the risk of employee class action. I mean, you've done your fiduciary duty by negotiating the best deal.
Right.
and making sure that PBM is abiding by the contract terms, and then making sure the pricing is up to par with the contract terms, and the contract terms in and of itself are the best deals out there.
Right.
And then I think the employer already checked off the fiduciary box, and then that could be a defense for any employee class action lawsuits.
Yeah, because I would think that if an employer is dealing with a fiduciary PBM and that client vendor relationship is clearly spelled out in the contract, that because I think it would be ridiculous to assume that any CEO or CFO or HR executive should be savvy enough to know every drug that's out there and what the fair cost of that drug should be, because it's so convoluted and opaque. However, if they are dealing with a fiduciary PBM, I would imagine that, I don't know that it would preclude them from being named in a lawsuit or having to defend themselves. That's a whole lot. Anybody could sue anyone, right? But I would think then that the onus would fall to their PBM vendor, and they would have to present evidence that shows that they fulfill their fiduciary obligation to their client,
Exactly.
and in fact, it is a fair price.
Exactly.
Right. So the PBM, I would imagine, can be named in these suits as well.
And they should be.
They should be.
And employers should have filed suits against PBMs, and they have an option to do so now. And because in my mind, PBMs are a functional fiduciary of the plan. PBMs are the ones who's coming up with the formulary. They're coming up with this network of pharmacies. They're coming up with the rebates, and prior authorization, all that. So
Yeah.
PBMs are the ones who's dictating the plan design. So in my mind, they are functional fiduciary of the plan, and they should be held responsible.
Cool. So we covered a lot of ground here. How do folks find you?
Call me, email me, just Google my name. I think my cell phone is also on my bio, so they could contact me, via phone or email.
So we'll get it in the show notes, but it's Dae Lee, right? Daelee.
Yes.
And your website
Yeah.
is what?
BIPC.com.
BIPC.com.
So Dae.Lee@BIPC.com. And my cell is 201-543-4027.
Awesome. So, hey, you shared a lot. Really appreciate you taking the time and being with us. Folks, until next time, love always. Take care. Bye-bye.
All right, that's a wrap. Hit like, follow, and subscribe, and we'll catch you next time.